I can't allow you to proceed while you're driving a vehicle.
No, I'm saying I'm parked. I'm pulling up parking now. It seems like you're practicing law from the bench. I'm going to respect your courtroom, but I disagree. Yes.
Sir, you have to stop interrupting.
Penalty and perjury.
If you stop speaking when I'm speaking.
Your Honor, he's coercing. And since there's no statute of limitation for fraud, he's wasting judicial resources. Honor my counterclaim to dismiss this matter.
So based on the proofs on the record, the court does find that.
All right, folks, buckle in, because today we're watching one of the most painfully stubborn sovereign citizens you'll ever see try to square off with Judge Hillman. And let me tell you, this judge, he actually went with patience. Not a smackdown, not a shutdown, patience. And honestly, that might have been his first mistake. Right from the start, this guy is already wasting everyone's time. The judge literally has to stop the hearing because the man is driving during court. You heard that right. Court is in session and this...
You said I'm driving the vehicle. Yeah, you need me to stop? I
need you to stop, sir. I can't have you driving while you're...
Give me 15 seconds, I can pull it back up to my family house.
No, I can't allow you to proceed while you're driving a vehicle.
No, I'm saying I'm parked. I'm pulling up parking now. I'm parking, right? 5 seconds. Okay, I'm done, Your Honor.
You recall in reviewing your business records if a foreclosure was conducted with regard to this property?
Yes, it was.
Objection, Your Honor, hearsay.
Okay, overruled. You may respond, sir.
On what grounds? So I could maintain the error for the record when I appeal this, if this don't go accordingly?
Okay, it's a business record, sir. That's an exception from
first-hand knowledge. Was he there at the closing table?
Doesn't need to be, sir.
Your Honor, it seems like you're practicing law from the bench. I'm gonna respect your courtroom, but I disagree. I disagree is tremendous. So, okay. Court reporter, can you please note that the honorable judge, I'm stating he's practicing law from the bench without facts.
But your objection is part of the record, sir. All right. You may continue, Mr. Dooher.
And is this a true, correct, and complete copy of the sheriff's deed of mortgage foreclosure, to the best of your knowledge?
To the best of my knowledge, yes.
And is this sheriff's
objection, Your Honor? Can he vow to that under penalty of perjury? That's the original document.
Your Honor, he stated this to the best of his knowledge.
No, under penalty and perjury, can he contest that that is the original document with the wet blue ink signature? Penalty and perjury.
All right, sir. That's not the question. The question is whether he can identify the document.
Under penalty and perjury, can it be yes?
Sir, you have to stop interrupting.
Penalty and perjury.
You can make an objection, but once you've stated your objection, you have to stop.
Yes, Your Honor.
All right.
And for the record, Your Honor, I do have counsel coming for this next court date. They obtained, as soon as he get back in the country, he will be jumping in to take care of this matter further. So I'll ask if you just give my counsel some time before any permanent decision is made so they can review these books, all interrogatories, so we can make a fair decision. Because I'm not arguing it's a debt, and I've been trying to honor the debt, Your Honor. I'm not arguing that it's a debt. I done did everything possible to honor this debt. They have not been in compliance with it.
And Your Honor, I would object to that, given this would be our third hearing, and he had ample time to get counsel.
Objection again.
All right, let's take one issue at a time, gentlemen. I can't be expected to remember 3 or 4 objections all at the same time. I'm going to overrule the objection on the basis of a business record exception. As to the request to adjourn the matter for Mr. Bay to retain counsel, I'm going to deny that request. Mr. Bay is
on what grounds, Your Honor? Because I never got served directly.
If you stop speaking when I'm speaking.
Genius is trying to argue foreclosure law while behind the wheel. The judge politely says, "Sir, I can't let you proceed while driving." And instead of pulling over like a normal person, the defendant goes, No, I'm parked now. I'm filling up parking. Excuse me? Filling up parking? Already you can tell we're in for a long ride. And it doesn't get any better. The moment testimony starts about his property foreclosure, the sovereign citizen pulls out the magic word he thinks is going to save him. Objection. And not just once. Over and over and over. Doesn't matter what's being said. Testimony about the sheriff's deed, confirmation of mortgage documents. It's always objection, hearsay. Objection, fraud.
And so
I never requested that. You stated that, Your Honor. This is my first time requesting any adjournment. to bring in incredible counsel who can handle this matter fairly on my behalf.
At this point, I don't even see that you have standing to participate in this case, although I guess we will get to the proof on that issue. So,
so Your Honor, you don't have my deed of records right there. You don't have me as the deed owner. You don't have me as a certificate owner in the record. I put all that on the record. So for you to say I don't have standing is kind of unfair from my understanding.
And was that redemption date September 27, 2021?
Your Honor, he's coercing. He coercing Mr. Dewhurst.
As a government record and or document recorded with the applicable recorder of deeds for this this document.
Okay. Any objection to that, Mr. Bay?
Absolutely objection.
Okay. And what's the basis for your objection?
He's a third-party debt collector. He's not a real party in interest, and he has no first-hand knowledge of any of the affairs that took place with this mortgage or at this closing table. And that Mr. Dewhurst he's not eligible to bind a corporation. Do he have the status of a CFO or a CEO in that company?
Okay, so the objection is that this witness doesn't have the
first-hand knowledge to any other matters.
Okay, all right. So the objection is overruled.
And has Carrington ever conveyed any of their ownership?
Objection, Your Honor. Objection.
What basis, sir?
Rightful owner as the title, rightful owner as complete ownership of the property. Can't just take away my interest like that without facts. You guys still have not had no verification of debt. What you have in your hands, Your Honor, we don't reached out. They cannot verify that debt, and they cannot verify that they ever loaned Rachel Brown and Matthew Brown any money for this mortgage. They can't. They can't prove that, and they haven't yet. And I've been waiting. I just want to know if they're a real party in interest, are they a real creditor in the amount, so we could handle any financial obligation if they are yet to prove that. Like you said, I got the deed, and it's sealed by the county records. I have the warranty deed as well, and it's sealed by the county records. Objection. Can you prove I didn't redeem and attempt to redeem? Can you prove that it hasn't been corresponding and negligence on you guys' behalf?
Overruled.
The property was foreclosed on and Carrington took control of it.
Okay.
Objection, Your Honor. How can you take control over something that...
Objection. Like he thinks if he spams the word enough, the judge will just throw up his hands and hand him the deed back. At one point, he even accuses the judge of practicing law from the bench. Now pause with me here. The man literally tells the judge of the court that he's practicing law from the bench. That's like telling a firefighter they're breaking the law by using a fire hose. But this sovereign citizen says it with a straight face, as if the court reporter is going to gasp and say, "Oh, wow, case dismissed." And here's the kicker. In between the endless stream of objections, he tries to make himself look reasonable. He says, "I'm not denying it's a debt. I'm just trying to honor the debt." But then in the same breath, he refuses every single record the court presents as proof. Folks, that's not honoring the debt. That's playing dodgeball with the truth.
Got the taxes in my name. I've been staying there the last year, and I have the deed and the warranty deed again for the record.
May I ask a question that would help?
You may, Mr. Johnson.
Objection, Your Honor. He's about to coerce him again. The question was clear. He could answer that on his own.
Okay.
He said he had 30 plus years of experience. This shouldn't be his first rodeo. He can answer that on his own.
Was there any redemption made by any party during that time?
No.
And none of your reflect.
Objection.
None of your record.
Objection.
And once again, you have not.
What's your objection?
That's not credible. That's not credible.
Sorry, this is not your time to ask questions, Mr. Bay. Mr.
Okay,
Johnson,
let me know when I'm credible to ask questions.
All right, Mr. Johnson, any other questions?
Has Carrington ever conveyed ownership of the subject property to any party?
No.
Thank you. No further questions, Your Honor.
Objection, Your Honor. Matthew Brown, not the owner at the time that they
Mr. Bay, this is your time to ask questions. So if you want to ask any questions to Mr. Dewhurst, you may ask questions to Mr. Dewhurst.
Okay, Mr. Dewhurst, is it not law that 15 USC 1692G requires verification of any debt?
Your Honor, I object as to relevancy.
Again.
Okay. What's the relevancy, Mr. Bay?
I'm establishing bounds for fraud. And since there's no statute of limitation for fraud, I'm going to make sure if they're not the original creditor, that it's fraud.
You didn't respond to the relevancy or how this is relevant.
The relevancy of 15 USC 1692G, it binds any corporation or anybody who's saying there's a debt or a balance to verify it.
Okay, so this is the time to ask questions, not to argue law.
No, I'm not trying to. I'm asking a question. That was a question.
You have a question regarding the facts for Mr. Dewhurst. Okay, you may proceed.
Yes. So again, Mr. Dewhurst, under 15 USC 1692G, do you have to verify a debt?
I'm going to have to object again regarding relevancy, Your Honor. This is, unfortunately, he does not have standing to bring any claims of verification.
Objection. I'm a real party in interest. Objection, Your Honor. He doesn't have any standing. He hasn't proven he's more than a third-party debt collector yet.
Your Honor, after the foreclosure period ran,
Your Honor, we don't know if this is credible foreclosure. Can I ask my questions, Your Honor?
All right, gentlemen, you cannot speak at the same time.
Next question. So, Mr. Dewhurst, are you conscious of the verification of that letter that been sent to your company twice that I sent with behalf of Matthew Brown and Rachel Brown that they're yet to respond from? My notary sent it. The notary republic sent it.
Your Honor, I would have to object.
Yes or no?
Sir, you have to let Mr. Johnson state his objection. Mr. Johnson, what's your objection?
Your Honor, she's asking the witness to respond to a vague request if he has any notice, but I would ask that he would only ask as it relates to the business records, Your Honor.
Objection, Your Honor. I sent that to the business and record department, and I sent it attention to the CFO of the company.
That's an argument. That's not a question. This is a time for questions.
Judge Hillman, though, he's cool as ice. He carefully overrules objections one at a time, explains the exceptions for business records, and gives this guy more chances than he deserves. But it's obvious what's happening here. This sovereign citizen isn't looking for justice. He's looking for delay. He knows his time is running out, and the only trick he has left is to stall. And by this point, I'm screaming at my screen, "Judge, just hit him with contempt already." Because you can see it plain as day. This isn't about the law. This is about a man trying to bury the court in nonsense until someone gives up. But trust me, the nonsense is only getting started. So after burning half the hearing with useless objections, our sovereign citizen decides he's suddenly a foreclosure expert. He starts grilling the witness like he's on Law and Order, demanding original...
That was in the form of a question. You didn't let me finish, Your Honor.
Okay, well, you can't ask multiple questions within the same question.
Okay. Well, Mr. Dewhurst, what was the problem answering the verification of that letter? If you have that in the record. So we've been asking for the original.
Objection, Your Honor. He stated that he was not aware of a letter.
You're right. Correct. So I should say then, moving forward, is there a problem producing the original contract with the wet bluing signature from Rachel Brown and Matthew Brown? If you have that in the records.
Okay, so you have a question for Mr. Dewhurst?
Yes, Mr. Dewhurst. Is it fair to say you cannot prove that the original, you don't have access to the original copy of the note of the mortgage?
Yes,
under penalty and perjury. Do the company have it, Mr. Dewhurst?
So you may ask another question.
And also, Mr. For you, Your Honor. So it's also credible and fair to say he has no firsthand knowledge of anything as well.
Okay, so that's an argument. That's not a question. Okay. So yeah.
All right, I'm learning. I'm sorry, Your Honor. Thank you for your patience. So Mr. Dewhurst, under penalty and perjury, can you confirm that your company followed all GAP procedures with this process?
Objection, Your Honor. So
I guess the last question, again, I just want to confirm that Mr. Dewhurst, you have no firsthand knowledge of the of Carrington Mortgage being a creditor in this loan for this mortgage. So that's still kind of broad, Your Honor. I want for the record for him to say, are you guys the creditor, or you don't know?
Asked and answered.
No, that's not asking the answer. I'm asking directly. Mr. Dewhurst, is Carrington Mortgage, can you confirm they're the creditor of this loan or this note, or you don't know? And I'm asking you that for lawful reasons.
And so by bidding the highest in the sheriff's sale, what interest does that give Carrington then in this proceeding?
We're then the creditor.
Okay. All right.
Allegedly. So that is true if that's the case. But if Your Honor or court, if Carrington can never prove they ever issued anything, is it fair or is it lawful to state that they never have the right to say they hit with the highest bidder with anything?
Any more questions for Mr. Dewhurst, Mr. Bay?
Not at this moment, Your Honor.
Okay.
Not at this moment. I'll let my counsel deal with that.
Okay. Does the plaintiff rest?
Yes, Your Honor. But if I may just conclude with a couple things, if that's okay.
Well,
objection, Your Honor. Statement and brief from counsel is sufficient for summary judgment.
And to show that there was indeed a foreclosure sale conducted on March 25th, 2021.
Objection, Your Honor.
And this is final argument, so that you can't object to that.
I'm sorry, Your Honor.
All right. Additional final state arguments, Mr. Bay?
Yeah, again, Your Honor, you know, he's wasting
contracts with wet ink signatures and throwing around the phrase penalty of perjury like it's a magic spell. The problem? He doesn't understand a single thing he's asking for. The witness explains the foreclosure process. The judge rules documents admissible under business record exceptions. All perfectly normal. But this guy just keeps shouting that the bank is a third-party debt collector with no standing. He's convinced that if he says those buzzwords enough, the entire mortgage just disappears. And here's where it gets flat-out embarrassing. He actually tries to lecture the judge about U.S. Code 1692G, demanding verification of debt like he's uncovered some secret loophole. The judge calmly reminds him this isn't the time to argue law, it's the time to ask questions. But does he stop? Of course not. He barrels ahead trying to cross-examine witnesses with YouTube law school nonsense. The court is drowning in objections. I lost count around 30. Objection relevancy, objection hearsay, objection fraud.
Coming with this because, again, I have proof on file and on record, correspondence. We try to resolve this matter. At this time, I would like to bring my counsel in. They'll be back in the States in a couple weeks. And also, Your Honor, can I request that Mr. Johnson put his bond on file? Can I get his bond information, his liability bond for this matter as well?
Okay, no, that's not an issue in this case.
I ask for you to just honor my motion, honor my counterclaim to dismiss this matter because they don't have. It's not nobody with real party and interest on this line right now. Nobody with firsthand knowledge is on this court case right now that can speak and contest to what's going on. So, with that being said, I ask to adjourn this matter or dismiss this matter because for failure to state a claim upon which relief can be granted.
An individual who's identified himself by the name of Amate Bay claims to have a possessory interest in the property, though he did not present any proof on the record today of any interest that would make him have standing to contest this mortgage foreclosure and this suit for possession. So based on the proofs on the record, the court does find that Carrington Mortgage Service LLC does have the right to possession and therefore a judgment of possession against Amate Bay and all occupants of the premises is granted.
What is my time frame to no, can you just for the record, so there's no contract with Amate Bay and Carrington Mortgage in this matter, right?
Sir, I'm not going to explain my ruling to you. I just ordered that the Carrington Mortgage would have the right to get an order of eviction, removing all occupants from the premises.
That's fine, Your Honor. I'll make sure it get overruled in a higher court. Thank you.
Okay. All right. That's all for the record. Thank you, gentlemen.
Thank you.
Your Honor. Have a nice day.
Even objects when it's his own turn to ask questions. At one point, the judge literally has to remind him, "Sir, this is your time to ask questions." And what does he do? Objection. And let's not forget, this man is representing himself. His house is on the line, and instead of hiring a lawyer, he's sitting there tossing legal gibberish like it's going to magically stop an eviction. It's like watching someone bring a water balloon to a gunfight and then acting shocked when they get drenched. By the end, he's run out of gas. He begs for more time, claims his counsel is out of the country, and then, cherry on top, asks for the attorney's liability bond to be filed on the record. Folks, that's straight from the Sovereign Citizen Starter Pack. Finally, Judge Hillman has had enough. He delivers the ruling clearly. The mortgage company has the right to possession. Translation? Sir, you're getting evicted. Case closed. And this guy? He looks the judge dead in the eye and says, "That's fine, I'll just appeal it and get it overturned." Like appeals courts are some magical reset button. No, sir, appeals don't erase your mistakes. They only correct legal errors. And guess what? The only error here is thinking objection is a get-out-of-foreclosure-free card. This is what always blows my mind about sovereign citizens. They scream about rights, refuse responsibility, and then act stunned when reality doesn't bend to their script. Gravity doesn't stop just because you don't believe in it, and foreclosure doesn't either.